Good morning, everyone. Today's Wednesday, 10 a.m. 10 a.m. and 10 minutes. We're 10 minutes late. And this means that we're starting another Canadian Immigration Live Q&A. We do this every Wednesday. And today I'm and Alicia Beckman-Bihari. We will be hosting this episode of the live Q&A. Mark is away. He's in the United States right now. And he will be back next week, and hopefully we will return to the three-person live Q&A format again. How are you doing, Alicia?
I'm doing all right, Igor. It's been an interesting little week. I don't know about you, but it's like military helicopters back and
Mm-hmm.
forth and back and forth, and like motorcades, and because of course the G7 was here, and so Calgary was a busy place for the last week.
Mm-hmm. Yeah, indeed. So we have a lot of things going on right now, and this is a pretty busy summer, I'll have to admit. So Mark just went for a conference. You, Alicia, just came back from a conference. And then there's a new conference here in Calgary, and then there will be a new conference related to immigration in Toronto in October. So it's going to be a busy season. Um, Alicia, so as we start this live Q&A, and while we're waiting for people to well in, what can you tell me about this conference that you attended? Do you have any insights?
Yeah, so it was the Canadian Bar Association National Immigration Section Immigration Law Conference that is held every year. This year it was in Victoria, BC. And it was really well attended. It was sold out, so lawyers from across the country, but not only private practitioners, also lawyers for the Department of Justice. So those lawyers who are working for the government, especially on federal court judicial review cases. So lots of federal court lawyers were there, as well as some judges, as well as representatives from IRCC and CBSA and the Immigration Appeal Division and the IRB. And so the tribunal members were there as well. And so it's a really good opportunity to actually have a discussion high level about immigration trends, about what's going on with IRCC program policy and guidance, trends for the future. And I think kind of the theme from the immigration lawyers was almost like people needed a group hug because it's been really tough, right? It's been tough, and not just for us as lawyers, but largely because it's been tough for everybody out there who's trying to navigate the immigration system right now because there's been a sea change. The ground has just completely shifted, the rules have shifted, the laws have shifted, and most people who came here 3 years ago who thought they had a pathway to permanent residence, it's like the doors are kind of closing left and right. And so it is harder and harder for people to find options. It's harder to maintain status. It's harder to find a work permit or find an employer who's going to be able to go through an LMIA process because of what's been happening with the unemployment rates. So it is really tough slogging. Cases are more complex because the law is more complex and there's been so many changes. So one of the big themes, and Mark and I talked about this a little bit last week, was there's a giant funnel of numbers of people who have been in Canada for the last few years, and there are less and less and less spots for PR. And so this is something that came out over and over again in terms of all the programs, right? The PNPs are largely starting to shut down, or they've already met their allocation targets, or they're making things harder, or they're reducing programs. Um, and then also we have express entry, and we have express entry where we have points that are so high on the CRS, and then the removal of those job offer points. So the landscape has really shifted, and it is harder for people to find pathways to PR.
Mm-hmm. Yeah. Um, okay, so we know that the PNPs are closing down, closing their doors. We know that the government does less and less CC draws, and if
Mhm.
they conduct draws, those draws are way smaller than what they used to be. And indeed, we do have clients who reach out to us, and sometimes our best answer would be to go back home and wait until the better time comes. And then hopefully that time comes before they lose their Canadian skilled work experience so that they can claim points and perhaps qualify for CC. But again, just for everyone to remind, we unable to answer the questions on what you should do in your individual situation in this live Q&A, and more often we would require to have a direct one-on-one with you to identify what would be the best course of action. For this live Q&A, Alicia will try to answer questions from the viewers and provide them with some generic information so that they can at least take that into consideration. And for everyone else who have very case-specific questions, we would direct them to book a consultation. Now, before we proceed to the questions, Alicia, there are a couple of things that we would want to discuss and share with our viewers, right? And so the first one is the news release that you shared with the team this morning, and I'm going to share my screen. And what I'm talking about is this Strong Borders Act. And this is something that we've been talking about for quite some time now, but at least now we do have the answers and more details about what the Strong Border Act will actually look like. So maybe you can give a little background as to what this Strong Borders Act is.
Yeah, and so right when we went to the conference, like literally the evening before, they announced this Bill C3. And so the difficulty with these omnibus bills is this is a very large draft act, and there are, I think, 140-ish pages in that act, and it's amending a number of different other pieces of legislation. One of them is the Immigration and Refugee Protection Act and regulations. And so this is where there was a bunch of concern because there's not a lot of detail if you go through Part 7, Part 8, Part 9 of that omnibus bill. What does this mean? What did they mean when they said that they could actually have more control over immigration documents? And so today, IRCC has said, here's what we mean. We want to have more control over immigration documents, but they're saying not asylum claims. So they're not going to use this particular change in the legislation to outright cancel refugee claims, but they are going to have increased powers to cancel or amend visas, electronic travel authorizations, or worker study permits. And so they do have to have some sort of public interest justification. And so they're saying the government is able to say, okay, if there's a risk to an immigration program, in terms of fairness, if there's health security risks, if there's misuse of government funded programs, if there's large scale emergencies, we could have more flexibility to cancel study permits or work permits or refuse to give people electronic travel authorizations or cancel them if they've already been issued or visas. So that is what they are clarifying about this. And they're saying the governor and council, who's the governor general, has to consider relevant factors, potential impact on vulnerable people, and then if the order is made to pause, change, or cancel the documents, it's not going to immediately take away status. So I guess that is some sort of small comfort that it's not going to immediately take away your permanent or temporary resident status. But so they are seeming to say that the same current processes for loss of status will stay the same. So that's the first part. The second part is, if you scroll down a bit, improved domestic information sharing. And so people were concerned, what do they mean by information sharing? Who are they sharing information with? They're saying it's not the US, it's not external governments, it is internal. And this is important because I've seen this, and I don't know if you have, Igor, more and more on files, but one of the big things that came out of the conference too was talking about the number of claims of misrepresentation that have happened, and it's over 100,000. And so immigration and CBSA are really, really, really cracking down on misrep. And one way they can do it is by information sharing. And so keep in mind that whatever happens when you file your taxes or don't file your taxes or avail yourself of employment insurance benefits, so unemployment if you go on EI, or if you take paternal leave or maternal leave, or if you get other social benefits or sometimes healthcare things, that can be shared with the provincial governments and with the federal government and with IRCC. So I have seen cases where CRA has given information to IRCC, or IRCC or ESDC, who's in charge of employment benefits, has given information to IRCC, and IRCC then comes back and says, hey, you claimed that you were working for this period to this period, but by the way, you were on unemployment insurance, so you weren't working. So let's talk about misrep. So I've seen that. So that's going to happen more because they're going to codify and make that easier to happen.
And
And it's
Alicia,
a
maybe here we can also add one more example of where people would really get trapped into this when they file their taxes and they just declare themselves as single.
Mhm.
When then in the immigration application they would disclose themselves as common law.
Yeah.
So I have a ton of questions from my Ukrainian clients who ask me like, would they actually check my taxes if I filed my taxes as single? And now the answer is clear. They will.
And that's a great example, Igor. And that's one of the things that I talk to my clients about as well when we're looking at spousal sponsorships or especially on express entry applications. Like if you're saying, oh, I have a spouse that's unaccompanying, but they are in Canada and you've literally already filed your taxes as spousal common law, you're in big trouble, right? So this is where people need to be completely honest and you've got to understand. Sometimes people don't understand that there is a common law partnership definition under Canadian law. So if you have continuously cohabitated as a spousal couple in a spousal like relationship for 1 year, continuous without breaks, then the government views you as common law partners. And so you've got to be super careful and consistent about that. So that's the point number two. And then point number three is talking about improving how asylum claims are received, processed, and decided. And this is because we have a giant, giant backlog of refugee claims, and that refugee claim number has gone through the roof. And it seems like that has coincided with people's study permits and work permits expiring. And anecdotally, we've heard a lot of students who've literally finished their studies, done their PGWP, can't get an extension to try to find or a change of conditions to try to find another work permit, and then somebody tells them, "Oh, file a refugee claim." And this is specifically what the changes in legislation are trying to target largely. So they're saying they are speeding up voluntary departures. They're ensuring that claims are decided only while the person is physically present in Canada, because sometimes those claims are old and the people have actually left. They are making sure that there's a referral process. So when somebody makes a claim, you have to get it referred. That's going to be sped up and streamlined. And then the next one is number four, also protecting the integrity of the asylum system. And this is the new um, dealing with students kind of provision. And so integrity measures to really clamp down. And so this is where they're saying, okay, if you look at people who have been in Canada for more than a year after June 20th, 2020. So if you came as a student and you've been sitting here in Canada for a year or more, then they are not going to refer your claim to the IRB. And they're kind of, splitting hairs by saying it's not a bar against making an asylum claim, but really your claim can't proceed if it's not referred to the IRB. So if they don't refer the claim to the IRB, then you have no ability to make that claim. But they are saying that you would have a pre-removal risk assessment, a PRA. So that is not the same. It doesn't have this, it's not a in-person hearing, it's a paper-based application. It's pretty restricted in what you're able to claim. But they're saying this will apply for people who, if this legislation passes, for people who have made their claims on or after June 3rd, 2025. So it's if Bill C3 passes, then that's what it's going to apply to. And then it's also going to try to crack down on people who are using irregular border crossings from the US into Canada. And so this is the second point, is that people who enter from the US along the land border, irregular crossings, who make a claim after 14 days are now also not going to be referred to the IRB. So that was kind of one of the loopholes before in the previous legislation. They're trying to get rid of that.
Mhm. Yeah,
So
and
those
Alicia,
are the
as we look into the asylum, which is often perceived as the last resort measure. For those people who don't want to file an asylum claim, they would typically file H&C applications. So going back to point one, would you
Mhm.
think it's possible that they would cancel the intake of the new H&C applications, or cancel the existing H&C applications in the queue based on this risk of immigration program fairness, or let's say misuse of government funded programs? Would you say
Yeah.
this is possible?
Well, I think it would be hard for them to cancel existing claims, but I think, you know, if it becomes so bad that they literally can't get through the backlog of H&C claims, it's possible that they could go to a quota system, right? Or they could
Mm-hmm.
go to some sort of expression of interest, or they could go to some sort of triage system where they say, once we hit our 20,000 or whatever it is for the year, we just won't take more for that year for processing. I don't know.
Mm-hmm.
But it gives them the tools in their toolbox to use.
Mm-hmm. All right. Well, this is interesting, right? Like we've been thinking about this for quite some time now. We knew that the Strong Borders Act is coming. We didn't know exactly how things will be implemented, but now at least some provisions make sense. And especially here, like this bar for making an application after you spend 1 year in Canada, it's very similar to how things are in the US. Like you cannot make an application after 1 year, um, after you came to States. So,
Yeah. And notice, Igor, too, it says even if you turn around, you stay here for a year, you turn around, you go back somewhere else and you come back in and then make a refugee claim, that doesn't work
mhm,
either, right? It says regardless of whether they left the country and returned. So
yes, yeah. All right. And then, Alicia, we do have a few more news announcements to make. So the first one, we'll start with the New Brunswick. Okay.
we'll start with some good news.
Yeah, exactly. So, just not long ago, New Brunswick negotiated that they will relocate 400 more asylum claimants to the province within the 2 year period, right? And so we knew that the federal government holds provinces ransom. They exchanged the PNP allocations for the number of refugees that they agreed to accept. Okay, and so just a couple of days ago, we have these good news, right? So the New Brunswick now received 4,250 PNP allocations for this year, which is an increase of 1,500 from the figure that they had in February. And so this perhaps becomes the first province that actually got the increase in PNP allocations, but it sets the stage for other provinces as well. Now, the question is, do you think other provinces will follow?
Well, I would hope that they do, right? I would hope that they say, look, we're a country that is vast and we have space and capability to welcome people. And so we know that the maritime provinces have historically not been overwhelmed with
Mm-hmm.
immigrants and newcomers to Canada. And so they are looking to increase their population, increase their diversity, try to increase their economy. And so it makes sense to welcome refugees in order to also welcome other economic applicants under PNP nominations or allocations. Most of those PNP types of programs in the Maritimes are employer based. And so making sure that you have an employer who's been vetted through the province who is able to support that application if you're looking at that PNP. So I would hope that other provinces follow suit and say, okay, well, yeah, we can take some more asylum refugee claimants or accepted refugees rather into our provinces and then yeah, we can increase our allocation for our PNP for economic immigrants as well.
Yeah, and it's interesting, Alicia. So right now, New Brunswick has as many PNP allocations as Alberta, but their population is like 5 times lower than what we have in Alberta. So they have like 859,000, and in Alberta we are close to 5 million,
Yeah.
which like it raises questions, right?
Well, they're a little bit, so the nominations are a tiny bit smaller, right? 4,250 now. Alberta is 4,875, so we have a tiny bit more. But yeah, because they have such a small population, theoretically they have more room to welcome people because there's more space, there's more services, there's more housing, there's more, but that needs to get played out in the communities and the municipalities as well.
Yeah, it's interesting. Like, we just have so many people coming to Alberta from Ontario and BC, and pretty much every other Ukrainian is in Alberta right now, and we have over 60,000 of those just alone. And then international students come to Western Canada. They follow our advice, go and study in Western Canada or in the prairie provinces, and then right now we're just like stuck in the same situation as New Brunswick, but compared to their population, the number of immigrants in that province, like we're in a way worse position than they are. And Alicia, as we talk about PNPs, there's one other thing that we want to share. So the
Mhm.
new release from OINP is the launch of the new employer portal. Okay, so maybe you can talk about this, Alicia.
hmm So this just came out last week on Thursday. So they were saying, all right, and there was some speculation, what's going on with the YNP? Why are there no notifications of interest? What's happening? And so what's happening is we had seen there was some legislation that they were trying to also tighten up the immigration proceedings as well as other things within the province. And so they are launching a new OINP employer portal. And so maybe you can zoom in a little bit, Igor. But basically, for many of the programs, we know that there are express entry linked and non-express entry linked applications. And then some of them, of course, have to have that employer support. And so I think probably as a measure to try to reduce fraud, they are making sure that now the employer is going through this process a little bit more directly. So instead of having a paper-based application, there's now going to be a portal for the employer. They need to make sure that this is going to be online submitted, secure documents, direct communication between the program and employers. So it's going to try to cut out some agents who are trying to hold people hostage. Um, Hopefully it'll streamline it by auto population. We'll see. Simplified tracking. But here's where the rubber hits the road. There's a required action. So if you currently have an expression of interest, um, you're going to need to probably redo it. And so what's going to happen is almost right now from June 20th to July 2nd, any existing EOIs are going to basically, you can't create a new one. And then on June 21st and 22nd, anything that's currently there is going to be withdrawn. So if you had an EOI sitting in the pool from before, it's going to be taken out. And then after June 27th, the system's unavailable. And then on July 2nd, the new employer portal is going to be open. And then that's when the employers have to register, provide employment position information, and then the applicant can re-register their expression of interest. So basically, it's giving employers another opportunity to reset and say, all right, do I want to participate in this program? Do I still want to support this person's particular application to the OINP?
Mm-hmm. Yeah. All right. Um, Alicia, so I think we reached the stage when 117 people are watching us live, and perhaps we'll move on to the Q&A part of the live stream. We'll start with giving a few shout outs to Sarab, to Batman, Arinze, Robin, and many, many other people who say hello. Okay, and so we'll start with answering some questions. Okay, so this one was the first that we've received. So unfortunately, COVID is back in my home country. My work permit is expiring in September. It will be difficult to leave with a 10-month-old to go back to my home country. What can I do?
And this is where So Igor and I are both Canadian immigration lawyers, and we are happy to meet with you if you want to book a consultation, and we can go through your situation one-on-one to try to figure out how long have you been here, what's your resume, what's your background, what are your language abilities, what's your family situation, and really try to figure out, are there options for you to change or extend that work permit, or is there a pathway to PR, or maybe there is not, and we will give you an honest opinion about what we think your options are. But anytime, so on this live stream, we are really trying to answer questions of general applicability. So something that's going to help as many people as possible. So we can't give you any advice. We can just give some legal information. But in general, unless you have some way to change or extend your work permit, if your status is expiring, you will have to go home. If you have been able to accumulate, hopefully, a year of high skilled work in Canada, then maybe, just like Igor was saying at the beginning, that 1 year of high skilled work in Canada, you can use it for 3 years, right? So once you hit the 3 year mark, and your profile from the time that you've submitted the profile or the time that you're getting your invitation to apply, the older work will fall off. But hopefully, depending on your points and your language and your foreign work experience, a lot of people come to Canada and as students, and they may not have had a year of full-time foreign work experience. And that actually makes a huge difference in your CRS score. So if you are able to gather your 1 year Canadian high skilled work, but you don't have your 1 year of foreign work experience, sometimes the best strategy is actually to go home, get a year of full-time foreign work experience, high skilled, update a profile, and see if you might be eligible for getting in an ITA in the future. But please book a consult if you want individual advice.
Yes. All right, so the next question we've received would be from Nash, because he sent a super chat and we try to give those a little more priority. So Nash is asking, if I have a PNP nomination, can I skip claiming sibling CRS points and just list them in Express Entry family information forms? Can I answer no to that question? And I don't need the additional points, so is it optional to claim those points in my Express Entry profile? Can I choose to answer no to the Canadian sibling question?
So you'll have to do so carefully if you choose to go that route. One question that I would have, Nash, is when you did your PNP and you got your PNP nomination, a lot of the provinces also give you points, like on the selection grid on the worker EOI, they will give you points for a Canadian sibling. And so just be careful, because if in your PNP, if in the EOI for the PNP, you claimed that you had a sibling and you put the documentation together, but then you don't do it federally, immigration is going to wonder why. Um, you will have to be careful in your express entry profile, because you'll have to be clear that you're answering no because you don't want to claim the points, but you still do have a Canadian sibling. Here's their proof that you guys are related. Here's their birth certificate, your birth certificate. Sometimes this happens in terms of my experience with my clients when there's been a falling out between the siblings, they no longer talk. It's not possible to get the siblings, permanent resident card or their driver's license or proof that they're currently living there because they don't talk to you. So it might be a situation where you can explain to IRCC, I don't need the points. I'm not claiming the points for a sibling. I already have my PNP. Maybe the PNP didn't rely on the sibling as part of getting the PNP. And you can just explain in a letter of explanation, I do have a Canadian sibling. Here are all their details. I don't know where they're living right now, or what have you.
Yeah, and Alicia, I would probably add that I would worry about misrep if you would answer no, that you don't have Canadian relative. And instead, I would just, for the upload spot, when they ask to upload the documents proving the relationship to a Canadian relative, I would just, as Alicia said, explain in the letter of, just upload the letter of explanation saying, please note, my eligibility does not depend on my points for siblings. I'm eligible regardless. You have to explain why you are still eligible, maybe recalculate the points and so on, and then just explain why you are unable to provide documents for the sibling. And again, like even if you have a sibling, remember that your sibling, if you want to claim points for the sibling, your sibling must reside in Canada, must because I had several clients who say like I have a sibling, and and like they have Canadian passports, but now they live in Mexico. Can they still claim points for it? And so the answer is often no, not often, but always no, unless the sibling actually resides or intends to return back immediately to Canada and reestablish themselves here before the application is submitted. All right, we'll move on with the next question from Sarab. So changing employers, so now applied for a new closed work permit under the GTS LMA on April 9th. So LMA was approved on 24th of April, but no work authorization is still available, right? So he has not yet received the work permit. Contacted the Member of Parliament, but no update. What should I do?
Sarab, so anything that says, what should I do? We need you to book a consult because we can't give you advice. But in general, in terms of immigration information in these situations, it really depends on what you put in that closed work permit and how long ago it was submitted. So what I always say to my clients is if you are in that world where you were waiting for the employer to get their LMIA and you had a work permit application pending, it does depend on when your previous document expired, right? So I don't know when your original work permit expired, if you're in maintained status or not. But if you are and you really need this closed work permit application to be approved, then make sure that you do a web form and upload a copy of that approved LMIA with you listed as an employee in the annex. So it's possible that IRCC has not yet seen that LMIA, and they could go ahead and process and refuse your work permit if they don't have proof that that LMIA has been granted. They will usually only hold a work permit pending the LMIA for 60 days. So you want to be super careful and you want to get on it and send them that web form to make sure that they match up the fact that the LMIA was granted before they issue you a refusal. So in general, make sure to upload that copy of the approved LMIA with you listed as a named worker.
Mm-hmm. All right, so the next one is from Aritse. And this one is more of a crystal ball kind of question, but what is IRCC doing with the family class PR quota for 2025? The Outlander applicants are taking all of the 70,000 slots, getting approved within 3 to 5 months, but my sister is trapped as an inland applicant for over 18 months now.
Yeah, and so Arinze, keep in mind that just because you are physically present inside Canada doesn't mean that you can't file a family class application, right? So if you are filing under the family class, that basically means that you will leave Canada if you are required to do so. So you have that dual intent. You are able, even if you're physically inside Canada, to file a family class application. And that means basically you can travel. If you file a spouse or common law partner in Canada class application and you have to leave for some reason, it's possible immigration could cancel your application. So that's one of the reasons why, it's not always the best idea to file a spouse or common law partner inside Canada. Regardless, if your sister is stuck, then in the processing times for the spouse or common law partner inside Canada class, the reason from a policy standpoint that immigration is taking longer on those applications is because in some cases, the family class applicants are physically separated. So they're literally outside Canada sometimes. And so they say, well, we want to reunite spouses. And if you are for sure, because the only time you can file a spouse or common law partner class application is if you are physically together, then those people are already physically together. And so there's less of a pressing need for them to be reunited because they're already here. And so that's why those processing times are going up and up and up. So 11 months for the family class application, 34 months for the inside Canada class. And keep in mind that if you have the inside Canada class, there's no appeal right either.
Okay. This one is good. Is it French CLB 5 or CLB 7 for Francophone Mobility Program after June 15th?
Good question. I've been looking. Yesterday. I was looking today. I see nothing. I see no news releases. I see no change on the IRCC website when I look at Mobilité Francophone. I don't know. It still says NCLC level 5. They haven't said anything differently. Um, so we'll have to see if there's a news release in the coming days. But it's a good question.
Mm-hmm. Okay. This one would probably require a consult. So, can you please let me know if my work permit expired while on a paid disability leave? Can I continue to collect this payment until my doctor releases me? The first question I have is based on what status document you still remain in Canada. So, before we can answer this question, we probably need to figure out your immigration status first.
Hmm.
Alicia, do you have
Yeah.
any other comments here?
Yeah, so Mateka, most of the provinces link healthcare eligibility with work permit status. And so when the work permit expires, then you got to work hard to prove to them that you have maintained or implied status to continue working. If you're on a disability leave and your work permit expired, um, that can for sure be a problem because did you try to extend or change your status? So before your work permit expired, did you try to extend it? Do you have employer support? Did you try to change conditions to just become a visitor? It's important to know what happened. Was this a workplace accident or disability? Is there a workers' compensation claim that's in effect? Um, Social benefits, so disability benefits, are normally separate, and it might depend upon insurance. So sometimes companies have private long-term or short-term disability, so you'll have to check with your insurance provider as well. But from an immigration standpoint, it's super important that you maintain your status, your ability to physically be inside of Canada. And then most of the time you need to also have tried to extend your work permit in order to be able to work in Canada. So lots going on there, and I'd say for sure book a consult.
Mm-hmm. Yeah, we've got one more super chat from Sarab. So he sent a follow up comment. And I'll start with pulling up his original question. So again, the new work permit expired. Okay, sorry, that's not an original, that's a follow up. So the original one was about the LMA, the GTS, and the missing work permit that he did not have yet. So the follow up was that the new work permit, he applied for the new work permit before the expiry of his original work permit, and the LMA was shared with RCC through the web form, but RCC now says that they did not get it.
Do another web form, make sure to take screenshots of everything, make sure that you show the screenshot of the uploaded LMIA, and then when you submit that web form, you should get an email confirmation back with the text in the body of your email about exactly what you submitted. Keep all of that on record to prove to them that you actually sent this information and the date that you sent the information.
Mm-hmm. Okay. So the next question would be from George. Um, any chance RCC will remove cooks from the trades category as cooks takes more than 80% of the slots? And also, the cutoff score will never go down below 500. So this one is a perfect question for you, Alicia, because you've been attending the presentation on express entry and category-based draws and selections, and you know the insights how they do those selections and draws.
Yeah, and so George, it's possible, right? Because IRCC tracks that. And yeah, I went to the presentation on express entry and the category-based draws, and um, there was actually a really good presentation, and and Tamara has really good slides, and she's crunching some of the numbers in terms of how many applicants, what are the not codes, what are the categories. IRCC says the reason that we have category-based draws is because they want to link it to economic outcomes for Canada. And so they look at the chronic in-demand occupations, ones that we usually and consistently do not have Canadians filling the jobs for. And then that is where they're going to target their list of category-based occupations. So cooks are on there, but you will notice that they do change the categories, right? And so they change them without warning. And then sometimes there's winners and sometimes there's losers. And so chefs, right? Chefs and cooks, and now just cooks. And so also most of the time for people to get enough points, they also need to have that red seal designation, trade certification qualification. So We'll have to see. IRCC is constantly monitoring, and so every year they do results-based analysis of what happened with their category-based draws. Is it resulting in the makeup of occupations that they want in terms of what are their permanent residents doing when they land? So,
Okay. This one's good. So before I book my consult, you need me to get my English test first? The test is scheduled for next Friday. And the answer is it's better to have one than not at all times, right? Because we need to assess your points. We need to make a reasonable projection as to what your score is. So perhaps if your question is not so pressing that you can wait until next Friday, then it's better to book a consult after Friday.
yeah. If there's a deadline and things are going to expire, for sure book earlier. But yeah, if you've got time, and it is really helpful for us to know what your language test results are, because it makes a huge difference in your CRS score and the options for various other programs. And so if you can wait and get those test results, then that is helpful information, because it gives us better detail in order to advise you.
Mm-hmm. All right, so Superman, I'm not sure if that's, come on, we have like Batman, we have Spider-Man, we have now Superman. Like, who's next?
Come
SpongeBob?
on, I
Or
want a
I don't
Wonder
know.
Woman. I want a Wonder Woman. She was my favorite.
Yeah, yeah. Okay, well, we're gonna have like 10 Wonder Womans tomorrow, like next Wednesday, so that's, we pulled our questions up. All right, so this one is actually a really good one. So I see that a lot of people are confused about accompanying and unaccompanying spouse, and it became like this hype point for many consultants and many media outlets over there in the immigration world, where they say, "Oh, things have changed. You know, you cannot claim your spouse is accompanying or non-accompanying anymore."
You
But the
never
things
could.
have not changed at all. It was always this way. So, Alicia,
Well,
would
things
you?
have changed in that they're cracking down on the
Oh
misrep
yeah,
now, Igor.
yeah, yeah. That's true. And things have changed now that RSSC has officially confirmed in one of the IMREP's responses that it may be seen as a misrepresentation, which is not surprising. It could always be seen this way, but now at least the screenshot or like the copy of the response was shared in the professional network, and everyone picked it up, and then like, oh, things have changed. No, they haven't. Essentially, long story short, if your spouse is in Canada, your spouse is accompanying. And if you list your spouse as non accompanying, that may be um, a signal that you're trying to game the system to get more points. Because we know that and Alicia, I love this one. I just got a notification on my phone from the news app on Apple phone, you know, like this major like news app that they have. And I like, the federal government is punishing families and prioritizing single applicants over the families, which is like, seriously, that's been like forever like this. But long story short, if you apply it with your spouse, the federal government wants to make sure that both of you can get economically established in Canada, and so they automatically detract points if you have a spouse or a common law partner. And to regain those points, your spouse needs to show their qualifications. So Canadian work experience, education, language test. They don't assess your spouse's foreign work experience. They don't assess your spouse's um, age. All they look at is the education, Canadian work experience, and language. And if you have those points and they maxed out, then your spouse will compensate for the points that were initially taken away from you. So if you're trying to list your spouse as non-accompanying while your spouse is in Canada, you're trying to game the system. Otherwise, you would list your spouse as accompanying because your spouse is in Canada. If your spouse leaves Canada and you list them as non-accompanying, expect that the officer may ask the question why. And you have to have a reasonable explanation why your spouse needs to remain outside Canada and why she will not accompany you later on. And it raises another question, like how legitimate your marriage is, right? Like maybe things don't go well between you at this moment, you know, and maybe that's why your spouse moved out. But again, if your spouse is trying just to relocate temporarily and then hope that you sponsor them later, that may not be taken well by the officer.
Yeah, and Superman, you're exactly right. The whole issue about non-accompanying spouse is because the CRS score is going to be lower if you list your spouse as accompanying. And so some people were getting told as a strategy, oh, just list your spouse as unaccompanying. And immigration has clearly said, well, that's misrepresentation. You are trying to game the system in order to get an immigration advantage when it is not reflective of the actual state of affairs. You are here, your spouse is here, both of you are physically present, you have a work permit, your spouse has a work permit or visitor status, and of course you want to immigrate at the same time, but you're just trying to say they're non-accompanying in order to get more points as the principal applicant and then turn around and sponsor them later. So yes, immigration will definitely question if people are in that situation. Now, they have said, of course, it's case by case. There is a theoretical argument for maybe the principal applicants here, they're international student, the other applicants back home in their home country. Maybe there's a small child involved that they're taking care of that didn't get a visa and they just came on a visitor status and then they're going back like 2 weeks from now, right? It's possible. There's sometimes various scenarios where it happens, but you do need to be super careful.
Okay. We now have the whole Marvel Super League over here. So the next one is from Batman. um, Man, I love those nicknames. So I'm an H-1B open work permit candidate. My U.S. citizen newborn was not part of the initial application. What should I do to include the newborn as my dependent? First one, you need to book a consult. And then we can tell exactly step by steps um, the process that you need to follow and whether you actually can include your dependent child um, and bring him to Canada. But it really comes down, right, to your individual situation. Theoretically, as a US citizen, the child would not need a visa, and upon entry at the border, if the child is traveling with the parents and the parent has a work permit that is issued, the officer may issue the visitor record for the child. But it's really tricky because if your child leaves Canada and then re-enters again, that visitor record is now void, and you will need to get either a new one or you need to figure some more sustainable solution, like a study permit, for example. I don't know, like, but for the newborn, study permit would likely not be an option, right? So you would need to figure something out, and this is something that we can discuss on the call.
Yeah, and this was something that came up at the conference as well, because it always used to be in the past that if a child had a visitor record and the visitor record would say was valid for 3 years, just like the parent's work permit application, then all right, they've got a visitor record. We won't worry about if they take a vacation down to the US to go to Disneyland, is that going to reset the clock and now they only have 6 months? And that's what has happened in a few cases we've heard about where immigration has taken the view even though the child has a visitor record, if they leave Canada, it resets the clock and now they have a new entry when they come back in. And if the officer does not give them a new visitor record, which most of the time they don't, it means that they only have 6 months from the date of entry. And most of the time, they don't even stamp the passport. So parents have to be super diligent about tracking every single time they might leave the country and then making sure that they take another trip with their child within 6 months or apply to extend from inside Canada and get a new visitor record. But then that's expensive. You got to keep doing online applications. So this is what we're talking about in terms of the difficulties on minors traveling with parents, because here's the worst case scenario, if the child's status expires and the parents don't even realize it, then the child's an overstay. And an inadmissible family member can make the parents inadmissible. And so, literally, the parents can lose the ability to work if they don't track the kids' visitor record statuses very carefully.
Mm-hmm. Yeah, yeah. And I had a case like this when a child was admitted to Canada and then they left and then returned back and they're like, oh, yeah, my child has a visitor record. I'm like, when was your last trip? Was it after you got a visitor record? Yeah, yeah, like a year and a half ago. And I'm like, well, congratulations. Your child is now an overstay for a year and a half. So you need to travel out of Canada and then return back and just the officer's mercy to issue the new visitor record and explain that you just did not understand the consequences of getting a visitor record and you leaving Canada. And luckily, the officer was a kind one, but not every officer is like that. All right, our time comes to an end, but we'll pull up a few more questions that I have piled up in a list. So this one is good from Inshal. So Inshal got admitted into University of Windsor, paid 1 year full GAC, showing funds of around 60K in savings, but there is a gap in academic history between 11th and 12th grade. And there's no gap between the bachelor's and I understand like master's or like this program. So class 12, okay, let's see. Oh, between class 12 and bachelor's. So there's a gap between class 11 and 12, but there's no gap between 12 and bachelor's. What are my chances of getting a visa for a civil engineering program in Canada?
So, Inshel, take a look. We've got a few blog articles on study permits and what are the factors, what are the main reasons for refusals on study permits. The world of getting a study permit has become more and more difficult because of the provincial attestation letters. So the cap on students, and then the fact that there's only a number of provincial allocations that the province has to give to various schools. So yeah, you're looking at a reputable university and an engineering program, civil engineering. Like these are not flaky courses, they are substantial academic courses. So that is good. But if you are applying for a substantial academic course, they want to know, IRCC wants to know, what is your language? What are your language scores? Because they do use really high language marks as an indicator of how well you'll do in an academic program. So make sure you're taking that general IELTS or CELPIP exam and hopefully scoring above sevens on everything. Right? So making sure that you've got strong language scores is really important. They will look at your marks. They will take a look and see how did you do in your previous programs of studies? What were your grades? And engineering is brutal. Engineering is one of the ones that will really grind you down. They're very tough. And so if you did not have super high marks coming in, it'll be even harder to try to get acceptance. And then immigration always looks at the factors that I've got in my article. They look at what's your intent, what's your kind of reason for linking this particular program? What are your career plans? How will this sort of education in Canada directly affect your ability to have career options in the future in your home country? They're going to say, why can't you do an engineering degree in your home country? So what is it that's unique or different about the program in Canada? How can you support yourself? Because international tuition fees are super expensive. So do you have the money to show that? You talked about the GIC and things, but where did the money come from? How did your family save it? If it was not your own earnings from work, if that came from parents, then making sure that you've got a gift deed, that you show exactly where the money came from. Lots of factors to try to figure out, is this something that you're going to be likely to get? And for sure, you can book a consult and talk to us about it. We can give you an opinion on how strong that application is.
Mm-hmm. Okay. Alicia, we started 10 minutes late, so we'll extend it by another 10 minutes. So we have 7 minutes left before the end of this live Q&A. And just as usual, I propose that we do a blitz, right? So we'll answer the questions very quickly. We won't be able to answer all questions, but we'll try to pull up the most relevant ones. So the next one would be from Harris. Any chance for big healthcare draw in 2025?
I would assume there's chances for like healthcare draws for sure, whether it's going to be a big healthcare draw all at once, maybe, maybe not. They seem to be doing targeted occupations. Largely, it's been Francophone, right? And oh, that was another big thing that came out of the conference. And probably Mark and I will talk more about it next week because we're running out of time now. But the reason that we have all the the Francophone draws is because of the Official Languages Act and because of the Standing Committee report that came out of that, which then got codified into immigration actionable items. So we've not had giant healthcare draws. They've been smaller than the Francophone draws, but the timing and the spacing of them really matter. So Igor has triaged the draws by healthcare, and you can see we had a couple in 2024. So we basically had February, July, and November. So there were 3. It's all kind of around the 3 to not quite 4,000 mark in terms of the invitations to apply. And so far we've had 2, but very, very small ones in 2025. And that is why the CRS score has been so high. So I would imagine that they will continue to do healthcare draws, but this is always the wild card. We just don't know how many ITAs and whether they will do healthcare draw back to back. Because if they do that and there's a decent number, like if they did 3,000 and then 2 months later they did another 3,000, kind of like when you look at the July to November of 2024, they did fairly decent draws and they were a few months, more than a few months apart, but the scores stayed reasonable, right? A 445 and then a 463 because those were fairly substantial draws. So we will have to see about healthcare.
Absolutely, I would agree that we do need more healthcare draws. Like as a person who spent my birthday night in a emergency, for the whole hospital, Alicia, they had just 2 doctors, just 2, for the whole night shift. And
Yeah.
some people were just leaving before they were called to see a nurse. They would spend like 6-7 hours in ER, and they would be like, okay, it's like 3 a.m. in the morning. It doesn't make for me to sit and wait for someone. I'll just wait until it's 8 a.m., go and get some sleep, and then go and see like a walk-in doctor. Crazy,
Igor,
crazy things
it
happen.
was it was really interesting because there was one guy who was really a fantastic speaker at the conference, and he works more in like a policy role for settlement for immigrants and advocacy. And he was saying one of the things they're trying to do is like awareness campaigns. And so they did a cartoon where they said, there's 2 people in this cartoon sitting in the ER of an emergency department at a hospital, and one of them says to the other, well, we should kick out all the immigrants and then this emergency room would be 30% less full. And then the other one turns to the other and says, yeah, and all the staff at the hospital would, be 30% less staffed as well, right?
Mm-hmm.
Because, if we were to kick out all the immigrants, then you would have more capacity in the waiting room, but you would lose 30% of your nursing and your doctor staff as well.
Well, if the first guy was right, then by January 2026, we'll see a waiting room 30% less. Because like the government wants to kick out 1 million people, and I don't see that significantly affecting things. What I think we should do, we should develop another program that would target people from overseas, and perhaps the government could select countries where they would find, okay, they have a matching education system, they have matching practices. Let them do the test before they come here, and if they pass the test, if they prove their qualification, we're gonna give them permanent residence upon arrival, just like for the home support workers. Why wouldn't that work? And then again, sorry, I'm taking this a little too personal, but I'm just like, I still don't have enough sleep after I spend like the whole night in ER. I still cannot recover from this. I have the sleep deprivation. So I
Yeah.
certainly on board with you, Harim, on this one. All right, so we have less and less time. This one is, do we see any processing improvements applied for the PNP non-express entry? And thank you for the good quality content. What would you say, Alicia?
Um, Not necessarily. Processing times do vary. It's been bouncing up and down. We've been seeing fairly consistent about a year for a non-EE linked PNP portal application. So probably it's going to stay about a year for some time.
Mm-hmm. Okay. Next one is the chance of being invited with 522 under CC Federal Skilled Worker. Here, Alicia, I will pull up the breakdown in points. So these are accurate as of April 7th, 2025. And the reason why this screenshot is very helpful is because it breaks down the candidates with scores above 500. So we can see that there are 16,000 people with the score under 525. And if you
In the
are
CEC,
in
just
CC,
C.
yeah. We don't have PNPs because PNPs would be higher. So if they do PNP draw, that would be likely a PNP specific draw, and they would completely drain the pool. And then we do have 725 federal skilled worker program candidates, but those have only a shot if they fit into one of the categories. So realistically, I would say yes, but only if they do a larger draw. Okay. Do you have anything else to add here, Alicia?
I did ask, I put it in, there was a poll, then they said, what do you request from IRCC? And I said, please, please, please put in the breakdown between 501 to 600. So we'll see. I made the request again.
Yeah. Okay. So this one, postgrad work permit expires in January. Received the acknowledgement of receipt for express entry based PNP. Can I start submitting a bridge application? Well, if you got the AUR, then yeah.
Yeah, Jan, take a look at my article on bridging work permits. So go to our blog, go to our website. I broke it down between the differences between the bridging open and the bridging close. So make sure that when you look at your PNP nomination, you've got to be really careful to take a look to see whether there's restrictions on employment. If there are restrictions on employment in your nomination, then it means that you cannot apply for a bridging open work permit. You have to apply for a bridging closed, which means that you need to have that employer portal offer of support from your employer. So take a look at that article. Be careful about restrictions on employment in your nomination certificate.
Mm-hmm. I have this wonderful comment here from Mark Holthe. Who's that guy? Thanks so much for running the live, guys. The American Immigration Lawyer Association conference in Denver is going well, meeting lots of U.S. attorneys looking for options for their clients in Canada. We are happy to hear from you, Mark. We're waiting for you to come back and share the good news next Wednesday. And yeah, like for our US based clients, we do have several options that we can offer most of the time. Just because the US based candidates are wonderful candidates. They speak fluent English, they have good education, they have good work experience. Perhaps they work in companies that have branches in Canada and they can transfer them there. Or they can go and study in Canada. There are many different options, and sometimes we have a little more to offer to our US based clients than what we have for our other clients from other countries.
Because of
So
the free
hopefully
trade.
the conference goes well, Mark. Okay, Alicia, 3 last questions and then we'll wrap this up. Okay. Okay, so this one is from Peter. I got a refusal because my letter of reference did not show the duties and job title, and my role in the institution was I was working. So please advise. And then perhaps I'll pull up one more question from Ke, who is facing a very similar situation, but does not have a refusal yet. So I got a reference letter from my work experience 5 years back, but it does not have the roles and responsibilities. So okay, you can see what happened to Peter. And the company is now closed, so I'm unable to get a new reference letter. What do I do now?
Mm-hmm.
Well, you don't submit your application with just this letter, that's for sure.
Mm-hmm. Yeah, and this is one of the things that's covered in our Express Entry Accelerator course. And so we talk about this a lot. And Peter, book a consult, talk to Igor. Igor's the one who's managing the judicial reviews right now. But if your reference letter did not show your job duties, did not actually go through, so 2 things, you need to have the activities of the lead statement. So what were you doing substantively in this role in terms of the NOC lead statement, and then a substantial number of the bullet pointed job duties that don't start with the word may. So the mandatory job duties you should be hitting, we always say, Mark and Igor and I say, and everybody basically when we file our applications, prove that you show 75% of those bullet points. And if you have some sort of kind of generic letter that doesn't say what you are doing, immigration is usually entirely justified in saying you don't meet the program requirements because it's literally in the ministerial instructions, and it's also in terms of what they define as proving your work experience. And so if you did not have that, you probably have to start all over again, create a new profile, get better letters of reference from your employers. Be really careful about misrepresentation, because why did they not put that in the first place? And you'll have to be careful that you're claiming the right NOT code, that you and your employer are in agreement in terms of what job duties you actually did, because it is entirely possible that immigration calls employers as well and can double check things. So please book a consult, but this is bad news, right? This is what happens if you don't, because the onus is on you to prove what your job duties, responsibilities were. They say if you look in the completeness check, we often go through that with clients. They have very specific requirements of what they view as a complete application. And if you do not have a reference letter that has your job duties, then it's not viewed as a complete application. So basically, there's almost very, very rare situations where you could ever do a judicial review because you didn't submit a complete application in the first place. You didn't even get it past the first post.
Yeah, and Alicia, so for Kay, I would want to direct him back to our Expert Entry Accelerator. Okay, you can go into the description under this video, and there will be a link that will take you to the Expert Entry course, which is a step-by-step video instruction on how to prepare your Expert Entry application. And in lesson 48, just as I showed earlier, we have this records of employment lesson. So that talks specifically about all elements that you need to include in your reference letter. If your reference letter is missing the email address of your employer or the phone number or the actual physical address, IRCC can't refuse your application because those are the mandatory elements from the completeness check. If you do not show that you performed more duties, like substantial amount of duties, and again, as we say, that's about 3/4, and then they can refuse your application. But in that lesson, we also talk about what can you do if you are not able to get the reference letter. There is a checklist with the ideas that you can try to confirm that you've performed the duties, even if they're not mentioned directly in the reference letter. So we would rely on circumstantial evidence, right? Like we would provide secondary evidence, like references from your past co-workers, maybe references or letters of support from your past clients, or maybe the contract or the job offer that you had. Sometimes we even rely on the website printouts, on your past projects, on the drawings that you signed as an architect, let's say. So there are many, many different things that you can think of just as you're trying to prove your responsibilities that you performed to work. Okay, and so the last one would be from Hernandez. Okay, so the category-based draws eligibility. Does the experience of at least 6 months need to be in the last 3 years? Yes, it does. If like the experience is 5 years ago and outside Canada, am I still qualified? No, you're not.
So Hernandez, take a look. Igor, maybe you can quickly pull up Express
Yeah.
Entry, go to the category-based rounds, and there's a section that says how category-based rounds work. And so in addition to meeting general eligibility under CEC or FSW or federal skilled trades, but that is rare, then you would have to also show that you've accumulated within the last 3 years, 6 months of full-time continuous work. It doesn't have to be in Canada. It could be in Canada, it could be outside Canada, but it has to be within the last 3 years, and you have to meet program eligibility for one of the other FSW, FST, CEC categories. 5 years ago is not going to get you qualified for the category based, but you can use foreign work experience for up to 10 years ago for general CRS points, right? So just keep in mind that category based, it has to be within one of those NOT codes within the last 3 years, either inside or outside Canada, but it's got to be 6 months full-time continuous paid work experience or equal amount of part-time work experience.
Yeah. And we'll wrap this up with a question from Melissa. Is it okay to book a consult with you just to review my statement of purpose and proof of funds for my study permit for any loopholes before submitting it, because I cannot afford the retainer of $5,000? And we would say yes, but we would not review the whole application. We will not tell you, okay, it's good to be submitted. We would perhaps note if we see any issues with the documents that you prepare. We will discuss the general nature, whether that's a document that you can potentially submit or not.
And Melissa, it depends, right? I've had people try to book like a half hour or 25-minute consult, and when we do a statement of purpose and a proof of funds, like each of those documents is probably going to be 10 to 15 pages long. And so it is not possible. Like I cannot do that. I cannot go through 30 pages of submissions, even in an hour. It's just not enough time to go through that properly. So it depends on how extensive your documents are. But if you book a consult, we can do what we can do in 25 minutes. But the reason that we have our retainer fees for the study permits is because it is so much detailed work.
Mm-hmm.
And so, maybe we can look at just your proof of funds and say, okay, well, I'm concerned about this. Where is this? How does this show the account? What's going on with your notarized gift deed? Can you show that you have had this money in your account for the last 6 months? How have you been supporting yourself? What's your budget? Where are your GICs coming from? What's the tuition? What have you already paid? What's your projected expenses? We could probably go through that in like an hour consult, but the reason that we want you to retain us and work with you directly is because we want to do a professional job. And it is very, very difficult to catch everything that we need to catch in 25 or 50 minutes when we're reviewing documents. So that's why we usually assess your situation, give you advice about different ways to proceed. Sometimes we can review one targeted document, but if it's extremely long and detailed, we might not be able to get to that in that time frame because we just can't do a professional job in that time.
Yeah, and here I would add that sometimes when we see the statements of purpose, we can tell right away this is not good because the statement of purpose would be like 2 pages long. I want to come to Canada because this is a country that welcomes immigrants. No, you don't want to put that on the statement of purpose. I want to study in Canada just because the education here is good. No, you don't want to put that on the statement of purpose. You need to explain your actual why. You need to explain why this program, why now, why not in your home country, how this program will help you in the future, how it connects to your past education, how it will help you advance your career or would be prerequisite to your future education somewhere else. All of those would be the elements that we would be looking at. The statement of purpose also needs to include your ties to your home country and so on. And so by just taking a quick look at some of the statement of purposes, it's easy for us to say, no, you don't want to submit with this statement of purpose. It's going to get refused. Though miracles happen and some applications get approved, even with some very bad statements of purposes, I'll have to admit, though it happens less and less right now, but it's still possible, right? And again, we during the consult, we will try to give you general guidance, but not like this advice that you can just type whatever we say during the 30 minutes, and just chat GPT it into a statement of purpose. That's not how it's going to be. So absolutely, if you need help, reach out, and then we'll try to do our best to help. Alicia, on this note, we will be ending this live Q&A. Again, reminder to everyone, go to our website if you need to book a consult. Our website is holthelaw.com. If you are dealing with an expert entry application or a TRV application or a visitor record application, you can go to our Canadian Immigration Institute website, and we have the DIY courses. I'm also wrapping up the creation of the citizenship course, which will be launched hopefully by the end of this month, because I keep postponing the release of this course just because we're so busy this summer. But we'll see you next Wednesday at 10 a.m. and hopefully Mark will be back and we'll share some good news from the AILA conference. And yeah, so prepare your best questions and we'll see you then.
Thanks, Igor.
Thank you.